Welcome to the capstone event in the 2019 Laundy Human Rights Project Just Communities Conversation Series, Inclusiveness, Rights, and Resilience to Populism. I'm Bethany Barrett. As most of you know, I'm a professor of political science and director of the Laundy Human Rights Project. We are very proud to welcome today a true civil liberties legend, Colleen Connell. Before I introduce her more fully, just a couple of words of thanks. I want to acknowledge that we are on traditional Potawatomi, Miami, Sauk, and Ochiti-Sakowin territory. I'd like to thank Joe Laundy, right here, the founder of the Laundy Human Rights Project and an alumnus of Roosevelt University, the current president of the College of Arts and Sciences Advisory Board, the winner of the first Distinguished Alumni Award that Roosevelt has given in the college, and the chair of the International Federation of Art Deco Societies, which I mention mainly because they're about to have a huge international conference that Joe almost entirely himself organized. Joe's generosity and initiative has made possible really transformative field experiences and seminars and training with human rights leaders for 11 generations now of Laundy Human Rights Project students. I want to thank in the College of Arts and Sciences, Deans Bonnie Gunzenhauser and Julie Rowan, and just want to say a couple of quick things about the Laundy Human Rights Project. So basically, it's unique in the nation in the way that it engages undergrad students in actionable human rights research. And we do that three ways. We do that by going into communities that are affected by challenges, human rights challenges here in Chicago. We meet with leaders in the field like Colleen here, who's doing just huge things to kind of combat the incursions on our rights that we've seen in recent years. And then we go abroad to look at how other countries are dealing with similar human rights challenges in their cities. So we'll be going to the UK a month from today, which I don't think we'll have Brexited at that point, but we'll be in the midst of figuring out how it's going to do that. So it's a really unique way that we take on a given human rights challenge each year. It's now my extreme honor to introduce you to someone who will probably not need an introduction for some of you. Colleen Connell is the first female attorney to lead the ACLU of Illinois. Prior to becoming the executive director, she served as the ACLU's associate legal director and director of the Reproductive Rights Project, which has probably never been a more timely time for that than right now. In that capacity, she directed the organization's litigation efforts on constitutional rights of privacy and reproductive matters and rights of privacy and protecting the rights of Illinois citizens to make decisions on reproductive matters and childbearing without undue governmental restriction. A native of North Dakota, she graduated from North Dakota State University and the University of Iowa Law School. Finally, I have a small gift for Colleen as a token of our appreciation and esteem. A couple of years ago, as some of you experienced, we were fortunate enough to host the legendary Ruth Bader Ginsburg here on campus. While she's a beacon of hope for many of us on many fronts, it's all too easy to lose sight of the fact that we are actually surrounded by people doing heroic work absolutely every day, breaking barriers, courageously being themselves, and in so doing, empowering others to stand up for themselves. And one of these sits before you. So a true heroine of standing up for the true meaning of civil rights and liberties here in Illinois and in the United States. The more that I've gotten to know her, the more hopeful she makes me about the chances that we have to make the world a better place, even in moments where it seems like that challenge is really quite overwhelming. So in that spirit, although she could have likely written this book herself, I wanted to present her with these little slivers of wisdom from another courageous, amazing woman which might help express at least a fragment of the admiration that I feel for Colleen. Little Ruth Bader Ginsburg book. Was it Rebecca's office? Yeah, there you go. So no coincidence there. So please join me in welcoming Colleen Connell formally. So we have actually structured today's conversation just as that, as a conversation. So while we have a few things that we want to focus on, we really encourage you to ask questions at any point, to jump in there if there's things that need clarifying, and then we will also save some time for a more formal Q&A at the end of our time together today. So I think you're going to start with talking about kind of where the ACLU is focused right now in this kind of current political moment.
Yes. So thank you for that. Oh, turn the mic on. Okay, hold on.
I gotcha.
Okay, there we go. Got it. There. Thanks. Okay, great. So first of all, thank you for that really generous and gracious introduction. I really appreciate it. And I very much appreciate the opportunity to be here today because as I guess probably the introduction to what the ACLU is doing right now, local action at the student level, at the university level, at the city level, at the state level is, I think, the most important front at which we can really, quite frankly, fight to defend our democracy. And I always like to think about it in the frame of the federal Constitution is a floor, not a ceiling, for the protection that we as a society can provide human rights. And so at a point in time when we have someone in the office of the presidency, I feel like he was a little bit like Darth Vader, he who shall not be named, or the villain in the Harry Potter series, he who should definitely not be named, Lord Voldemort. You know, I think that it's really important that we take advantage of these local opportunities. And so some of the things that the ACLU has been working on here in Illinois and that have been really, quite frankly, you know, important, not just barriers to violating human rights, but more importantly, perhaps, or as importantly, real advances of human rights protection, include on the legislative front our groundbreaking enactment in the General Assembly this session of the Reproductive Health Act. That Reproductive Health Act is a state law that will be a bulwark should Roe versus Wade, which protects the right of women to have an abortion, should the Supreme Court overturn it, or should it continue to really whittle away at the protections that the federal Constitution has been interpreted to provide for the rights of reproductive decision-making for the last 45 years. Basically, the Reproductive Health Act will protect the right here in Illinois. It recognizes in its opening paragraph that the right of every person to make and effectuate decisions about whether and when to have a child is a fundamental right that's protected under state law. And in addition to setting up a regulatory scheme that treats reproductive health care just like every other health care, in which the patient's interests comes first, the law goes on to create, sort of digging into the legal weeds a little bit, a legal cause of action that a person can basically bring an action in court if any local governmental unit or the state of Illinois itself were to pass some kind of governmental action that restricts reproductive rights. So for example, one way in which we've already begun to use this new law, which went into effect on June 12th of this year, affirmatively, is a downstate county was in the process of negotiating the purchase of a Catholic healthcare facility to use as the county hospital and healthcare facility. The Catholic healthcare provider, as is the tradition under its corporate governance structure, basically was attaching as a condition of the sale the requirement that the local county continue to impose restrictions on care that followed the Catholic hospital's compliance with the ethical and religious directives of the U.S. Conference of Catholic Bishops, which governs how Catholic health care providers in the United States operate. And as you can imagine, those ERDs is the acronym, so ethical and religious directives. Those ERDs prohibit the performance of abortion in Catholic facilities or facilities that used to be Catholic but have now been sold to someone else. Prohibit the prescription or dispensation of contraceptives in that facility. Prohibit certain types of assisted reproduction, such as in vitro fertilization, and really put restrictions on the kind of medical care that people who are, perhaps considering or are transitioning to really, I think, conform their own, gender identity to, what their lived experience has been. So we, the ACLU, said, hey, wrote what we call a demand letter. Hey, Clinton County, you can't, if you go ahead and buy this Catholic hospital facility and then, reopen it as Clinton County Public Health Facility, you cannot impose those restrictions on care because that would violate the Reproductive Health Act. And if you do that, we, the ACLU, will sue you. And here are the provisions of the law. And so the county has really backed off its decision to go ahead with that, and are considering whether they can either find alternative space or basically say, hey, if you want to sell to us, you can't attach these conditions as part of the sale. And so, it's a really good example of how the law can be used, state law can be used affirmatively, and also shows the importance of thinking about all the different kinds of tools as a human rights advocate, which I hope you all think about a career in, all the kinds of tools that you can use. It's not just going to court, it's also using the legislative process as a way to affirmatively protect and expand human rights. And so that's one example. And we had a very successful legislative session. We made permanent the requirement that law enforcement record and report data about the race and ethnicity of both pedestrians and drivers who are stopped by law enforcement. We actually did some great cleanup work on our civil asset forfeiture law, and sort of a whole range of some other technical fixes, including a fix that really enacted into law a constitutional requirement as affirmed by the U.S. Supreme Court this term, which is basically that law enforcement has to have a warrant consistent with the Fourth Amendment's requirements before it can basically track location devices or location identifying data collected on people's personal devices. So all of those shows how you can use the legislative process. Going back to perhaps a tool that the ACLU is more conventionally known for, we had a very successful, against all odds, federal litigation year as well. So we were part of the litigation that the Illinois Attorney General filed against the against the Chicago Police Department. And so forgive me while I unpack the history a little bit on this. But again, it's why I think it's so important to remember that there are local tools that we need to really use creatively, robustly, and really, quite frankly, quite aggressively. So during the last 2 years of the Obama administration, the U.S. Department of Justice launched a very broad investigation of the Chicago Police Department and its excessive use of force, particularly against people of color. In the waning days of the Obama administration, after Trump had been elected, but before he was inaugurated, the Department of Justice released its report that basically concluded that the Chicago Police Department was really in violation of the Constitution as well as many federal laws with respect to how the police department was operating. And the Obama administration basically said, we're going to get the city of Chicago to enter into a memorandum of agreement that the city will basically enter into a consent decree with the Department of Justice. A consent decree is again, a legal tool. You basically sue somebody, you settle the case short of a trial because the other side admits essentially wrongdoing, and then you lay out a remedial plan that says this is how we're going to reform the department to make sure that the department acts in a way that's consistent with federal law. So that happened in the last days of the Obama administration. One of the first things that Jeff Sessions did as Attorney General was basically revoke that memorandum of agreement and basically said, the Department of Justice is out of the business of supervising police departments. And at the same time, we have President Trump, saying, I think police should rough people up. And again, I think you took an oath to defend and protect the Constitution of the United States. The Constitution of the United States imposes limits on use of force. Mm-hmm. And what is wrong with you? To quote, Representative Bobby Rush yesterday, what the hell is wrong with you? I mean, sometimes it just sort of cutting to the quick is pretty important. So fast forward, a year after that, the Illinois Attorney General filed, I think, a very important groundbreaking lawsuit in which the Attorney General Madigan basically took up the mantle that had been dropped by the Department of Justice. The ACLU filed a companion suit, and basically we were part of the settlement process that ultimately did end up in a consent decree. And one of the provisions of the consent decree that we specifically demanded and that got written into essentially an enforceable court order is a requirement that the communities in Chicago be involved in the police reform process. And so our clients in that case are such organizations as the Community Renewal Society, Communities United, One North Side, several other community-based organizations who have police reform as an important part of their community activity. Our clients, these community groups, will continue to have a seat at the table as the consent decree implementation process proceeds to reform the Chicago Police Department. So again, that was a really important way in which state government, Attorney General Madigan, and advocates, ACLU and others, responded in the face of, I think, a really disastrous development by the federal government. Mm-hmm. So, just to recap what I said, I mean, the ACLU, both here in Illinois and nationwide, has a professionally staffed office in each of the 50 states. And our approach to the gross constitutional and human rights violations spawned by the Trump administration has been twofold. We, the ACLU, are going to do everything that we possibly can do to challenge those outrageous actions by the federal government in every possible forum. So that's sort of one, one very important strategy. Our intersecting strategy, of course, and particularly in states where the local political climate allows that, we are going to use all of the tools of state and local government in an effort to protect those rights. And just one sort of last way of sort of sometimes how those two areas really meet. A couple years ago, the Illinois General Assembly passed the Trust Act. which was in some ways a sort of a statewide welcoming city ordinance, but with a few more teeth. And the ACLU and many of its partner groups are actively exploring or in litigation to try to enforce the provisions of the Trust Act against local governmental officials who are violating the specific terms of the Trust Act, which say local law enforcement officials cannot cooperate with like Immigration and Customs Enforcement, ICE, on such things as like detainer holds in jails. So again, the bad federal policy, we come up against, and we try to figure out, what ways in which we can use state law or make state law creatively to try to protect those human rights. Now, in some ways it's also, I would say, a law professor's exam writing dream, because I've just given you the high points, and there are all sorts of really interesting, if I take off my outrage hat for a moment, there's some very interesting structural constitutional issues as well, and I'm sure you've all seen record of those. I mean, when the city of Chicago strengthened its welcoming ordinance a year or so ago, the first thing the Trump administration said it was going to do, withhold all federal funds from the city. And they have some power to do that under the spending provision of the U.S. Constitution, but it's pretty good. It's got to be anchored to basically what the federal funds were used for, and it can't be sort of a broad scale. No federal money comes into Illinois. So again, some very poignant human rights issues, but also some really interesting structural issues.
Yeah, so I think there's so much to talk about, right, in terms of the many different avenues of incursions on rights that have happened in the last couple of years. And what I thought was so interesting when you and I were first talking about this conversation was the way that, because I think I referenced reproductive rights just because I know that that's obviously kind of where your original area of expertise was. And you were able to connect that to white supremacy, to a kind of other civil liberties violations that actually really affect everybody, whether or not they're particularly specifically concerned with reproductive rights or not. So I was wondering if you could talk a little bit about that connection. I think it's so
absolutely. So I'm going to connect some of the factual developments that have intensified in the last 3 years to sort of some of the persistent themes in constitutional advocacy and really, quite frankly, really questions that have long reverberated in this country about race and gender. So the factual connections are that there is a tremendous amount of factual material that's being validated, as we sit here, that connects the growing misogyny in this country that we have really seen. I want to say just exposed, because I think a lot of it's always been there, to the white supremacy movement, and also the anti-immigration movement, which is really also the white supremacy movement. And the attacks on reproductive rights, and when I quoted this passage recently in a speech to the City Club, somebody came up to me afterwards and said, "Was that quote from somebody who is still alive?" And I said, yes, it was a quote that this person made, a couple months ago. But it's basically that if white women, and it's very specific in race, if white women have choices to get an education, to have a career, then white women are not going to be reproducing at the number that we need to keep whites in the numerical majority in this country. And the next thing is basically and whites are being replaced. And you hear, this replacement theory that has become such a, it seems like omnipresent meme on sort of the, the far right and white supremacy channels. We will be replaced. And you think back to the march in Charlottesville. One of the chances they were going by the synagogue was, "Jews, you will not replace us." And
can I just ask, who was it that said most recently? Because I think it was someone well known, right? That said, white women aren't having enough babies, right? Yeah.
Right. Yeah. So anyway, if you'll give me just a minute, it's Roger Devlin, who's a longtime white nationalist, and what he put it really bluntly. Women's liberation has actively hurt white men's ability to procreate because when white women have choices, they are less likely to get married, have children, and perpetuate the white race.
Wow.
Distilled to its essence, if women have choices, they won't reproduce. And so guess what their solution is for this? Yeah, exactly. It's sort of like, okay, well, let's just eviscerate legal rights, reproductive rights for women. And, I would say that there's, probably, a kind of malicious consistency in their logic. I mean, it's really, well, hey, one way to, really, stop the demographic changes in this country is to really, bump up the rates of reproduction among white people, and again, let's stop immigration of particularly people of color. And you think back to the, we want more immigrants from Scandinavian countries, but not from from Central America and Africa, and there's a kind of real sick consistency to all of this, and when you actually, and I will say that I have spared myself this, but when you read the literature, and the Anti-Defamation League produced a report in 2019 or late 2018 that really ties all of this together. Their poor researcher actually, I think, had to go to some of these far-right websites.
Right.
I spared myself that. I just read the ADF report. That alone was terrifying enough. But there's really this consistent theme. What I find, and this is where I'm going to go all lawyerly on you, what I find even more terrifying than the rantings of the far right is a quieter, but I think ultimately more pernicious effort that has long been ongoing in legal and constitutional circles. And again, this is not new. I said long ongoing, but I didn't realize how long it had really been going. It's really been part of the constitutional conversation that Congress, the federal judiciary, lawyers, and activists have been having, quite frankly, since the 1787 and the Constitutional Convention, but continuing through 1865, 67, 69, when the 13th, 14th, and 15th Amendments to the Constitution were drafted and ratified. And when Congress, pursuant to those amendments, passed the first civil rights laws in the 19th century, and they got narrowed and limited by the courts. And then when we see, the really profound constitutional explosion of protection of rights under the Warren Court, as well as the 1964 Civil Rights Act and the 1965 Civil Rights Act, what you see writ large is an effort to make the Constitution and the laws of this country protect all of us. And that, to state the obvious, is not the status quo of the original Constitution, which did not recognize and afford the full scope of rights, obviously, to First Peoples, African Americans, women. And in some of the early permutations of the voting requirements for both state and federal elective office, which the states controlled, really you had to be a white male of property to vote. And so, the first founding of this country, by which I mean the first Constitution, not the Articles of Confederation, really many of us in this room were quite frankly invisible in the eyes of that document. And so the 13th, 14th, and 15th Amendments, each of those provisions, each of those amendments had a provision that specifically granted Congress the power to enact federal legislation to protect the substantive rights that were laid out in those post-Civil War amendments. And, among the really important issues that the framers grappled with and that you see embodied in the first generation of civil rights legislation were such issues of whether the protections, for example, of the 14th Amendment and 15th Amendment protected against private action as opposed to just state action. And so, as I mentioned earlier, the Supreme Court, in a series of what are actually now known as both the first civil rights cases and the slaughterhouse cases, basically gutted those first generations of civil rights law. Fast forward to the 20th century, and by that I mean no disrespect for the really amazing struggles that went on during that really 100-year gap. You see the Warren Court really grappling with an expanded vision of the Constitution, and really in a series of decisions, making the Constitution protect the rights of all of us. And again, going back to my first area of subject matter expertise, which is women's rights and reproductive rights, and here again is to Ruth Bader Ginsburg. The notion, that gender should not, that you shouldn't be able to, discriminate against someone on the basis of their gender is something that, now Justice Ginsburg really in some ways, worked her entire early career to create the jurisprudence that protected that. Roe versus Wade came out of a series of decisions, not all of which involved reproductive rights or even women's rights, in which the court protected the kind of sort of fundamental human decision-making that the framers never thought to include in the Constitution because it was so obviously an individual right. And just starting with marriage. You can look in the Constitution as long as you want, and it does not even mention marriage. And the framers would have thought that if you, I should be careful, I don't probably know what they thought, but I mean, just the laws of the time. The notion that, government would restrict basically a white man from marrying somebody who he or his family chose for him is absurd. I mean, that just was not a concept that existed. Likewise, with the ability to either accept or reject medical care, that comes out of not just our common law history going back to England, but goes back to, in some ways, not in some ways, quite frankly, to the ancient Greeks, and the concept that the reason that a physician is allowed to touch you in a way that would otherwise be considered a battery is because, wait for it, and you guys all know this, you gave your consent. Now, this concept of informed consent is basically protecting individual decision making. I'm sick. I'm going to someone for help or advice to help cure my sickness. Is really, quite frankly, an individual decision dealing with your right to, in some ways, control your own body. And so what Roe and what the decisions before Roe, including the right to marry, even if your spouse is of a different race, the Loving versus Virginia case, the right to use contraceptives, and then finally the right to have an abortion, really reflect a law older than the Constitution that was, really continued in the Constitution, that fundamental to the notion of freedom, is the right of individual people to make decisions about their own body. And what we know, is that for much of the first 200 years of the country's existence, people of color did not have that right protected, and women did not have that right protected. And the deprivations extended beyond just decisions about physical autonomy. It wasn't until the early 1970s that there was the federal Fair Credit Law passed that basically made it a federal right for women to have access to credit in their own name. I mean, that may seem like ancient history to many of you, but not to me. I mean, those laws were enacted when I was in high school. I mean, and I grew up in a time when a lot of married women could not get credit in their own name. You had to have your husband sign, if you were going to make an application for a credit card. And the consequences of that are obvious. Should you get divorced? Should your husband die? All of a sudden, again, you're invisible in the eyes of the law. And so what I find, connecting back to this white supremacy movement, what I find so terrifying is the school of thought that is, has legitimacy in constitutional circles and is really a fundamental driver of the Federalist Society's view of who should be on the federal bench. And it's, again, why the Trump administration has been so dangerous with 160 judicial nominations, is that the Federalist Society believes in this originalist view of the Constitution in which many of us are not protected by the rule of law. And they want to think about what the original framers intended, and they very conveniently sort of disregard the 13th, 14th, and 19th Amendment to the Constitution. And I think more emphatically, also not just ignore, but want to undo the factual and demographic changes, of this society.
I just want to draw a line under that, a sort of stark contrast that you just implicitly pointed out, which is when we think about Roe, or we think about kind of any of the cases surrounding it, right? Like, so that we think of that as being an abortion case, and many will say like those are all sort of like left-wing issues if you're someone that's maybe like more aligned with the current administration. And yet, as you point out, it's actually about bodily integrity, although I don't think you use that term, which is considered to be like the most core of the core rights under the Universal Declaration.
Absolutely.
So like it's really interesting how much broader Roe is than most of us think of it as being, even those of us who think about this stuff a lot.
Right, and I think it really underscores the importance of seeing Roe contextually.
Right.
And I don't just mean the constitutional context, but this broader context of human rights, this broader context of sort of the development of the law, not just over the 200 and some years since the Constitution was ratified, but really going back, 3,000 years. And this notion of bodily integrity is just so very fundamental.
Right. Right. So you would see that as kind of an example of one of the ways that really the current administration or current kind of jurisprudence is attempting to really like rewrite our fundamental understandings of the Constitution itself, right?
Absolutely, absolutely, and that's why again I say it is so terrifying because it has a veneer of intellectual and constitutional respectability. And I think we should really call it for what it is, and it's really an effort to write many of us, out of the constitutional protections. And if I can just elaborate on that just a little bit more, and why I do think it is deliberate and not really just starting with the abortion issue, but going more broadly, why it's not really a reflection of the respect for life. That the anti-abortion activists and the constitutional theorists claim that it is. And I just want to be very clear. I am not saying that that everyone who opposes abortion or everyone who has a personal, moral, or religious objection to abortion is a white supremacist. That's not what I'm saying. I think that there are lots of well-intended people who just personally have a moral construct in which they think that an embryo and a fetus is a member of the human family deserving of the same rights that everybody else has. Where I differ is on the ability to impose your moral beliefs on other people. And this is where there is a huge legal inconsistency that I think, again, exposes the issues of sort of the originalists. As Bethany knows, because she and I have talked about this, there is it really comes out of common law. There are a number of cases on the books, mostly out of state court, because these are where these cases come up, where there's a question of whether we are going to force a family member, usually, to give a donation of blood, bone marrow, or a kidney or a lobe of a liver, all organs or bodily tissue that can be donated without killing the donor, to a family member who needs that transplant or transfusion in order to continue life. And the courts universally have said, no, we are not going to allow this. A Pennsylvania court basically said, point blank, the difference between a civilized society, a society of the rule of law, and a country like Nazi Germany, which did not respect individual rights, is our willingness to say that we will not allow the law to be used to basically force this invasion, unwilling invasion, into your bodily integrity. And yes, we realize that the person who needs the transfusion or the donation may die if they don't get it. And we may even recognize that the family member may have a moral or an ethical obligation to consider seriously, making that donation. But we, the court, do not think that we have the constitutional power to order that. And then again, to just sort of connect this with how women have often been treated as second-class citizens. Notwithstanding a number of those cases that got decided in the 50s and the 60s, or I should say the 60s and the 70s, people stopped bringing those cases because they weren't winning. Fast forward, there are a number of cases in which, and they often arise in the context of a pregnant woman who is refusing medical advice that's being given in an effort to preserve the pregnancy or protect the fetus. And in a couple of cases here in Illinois that I've been involved in, there's been a tension not just between the woman's bodily autonomy and the fetus, but also the woman's religious beliefs. Mm-hmm. And so there have been a number of cases in which we have litigated in which the state's attorney's child protective unit has tried to force a pregnant woman who's a Jehovah's Witness to accept a blood transfusion. And I'm oversimplifying, and I apologize if I do disservice to discussion of the Jehovah Witness beliefs, but basically it distilled to consider blood transfusions basically immoral because they view it as sort of eating blood. And we may not believe that, but that is a very real personal belief. And there are, again, cases in which male Jehovah Witnesses have refused a blood transfusion, even recognizing that it could mean their death. And the courts have said, or nobody would bring that case, yeah, we're not going to force you to violate your religious beliefs. It doesn't hurt anybody other than yourself. And the courts have, to their great credit, basically followed that line with respect to pregnant women. So the notion, really quite frankly, that a fetus has the same legal rights as a pregnant woman is just not borne out. And that's not how we treat it really, quite frankly, in any other context, except really in this abortion context. And so, again, trying to, sort of write a view of women as second-class citizens into the law, by virtue of saying, people have bodily autonomy except for pregnant women, is hugely problematic. Just to state the obvious.
And there's a long history of that too, actually, right? Sort of this like very big double standard between everyone else, including all women, and then pregnant women.
Right, yes, go ahead.
I don't know if this is keeping in line with what you're saying, but would it be feasible, or is it possible that the federal government can limit women from having babies if they're on welfare? I know that's
So we've actually, the ACLU actually challenged that, and we have said, we have won the cases, thus far that have said, it's again bodily autonomy. The right to decide whether or whether or not to have a child is fundamental with the individual, and you should not be able to condition the receipt or the denial of a governmental benefit on the person's willingness to forfeit a fundamental right. In some of the welfare, I'm going to put air quotes, welfare reform efforts, we, the ACLU, and our allies have not been as successful in challenging the kind of lifetime limits or time limits on how long people can receive those benefits, even though we think it's a similar diminution of sort of bodily autonomy and fundamental rights. But you're spot on in recognizing the connection of that, and your ability.
Why women have choices, and they're going to have babies, and then
right.
Not going to be the majority anymore. So
right.
So maybe we can limit on this end. I mean, in many places of the, we won't, just like you earlier said, we won't provide federal funds to shower if they increase it. So I have to understand saying, okay, well, we'll limit your funds if you do better. There's some aspects of it that does make sense, but like you said, within the Constitution, I mean, I think what Roe Wilson said, the Constitution was a much simpler time.
Right.
Now it has to grow and adapt to our time.
Yeah.
So.
Yeah, but that is actually, I think, exactly the reason. I mean, and I think that, again, this is some of the racism that is so invidious and that's so rooted in so many of our systems. So much of the communications material oppositional to, I think a human rights standard of benefits is, of course, we've all seen, the bad ads about the welfare queen. And again, it is always a woman of color who's portrayed in the visuals on that. And it disregards the fact that, and I haven't looked at this data in the last couple of years, but every time I've looked at it heretofore, it's really been, sort of numerically, there are more white people who receive federal AFDC and TANF benefits than people of color. And of course, and it's not, I want to deny anybody those. I mean, we are a rich enough society that we should be able to actually make the commitment that everybody has a decent standard of basic, food, water, education, housing.
Yeah, absolutely. In fact, one of the things, so, this class is, or which there are some members of here, is going to the UK in a month. And, that's one thing that I find is always really shocking to students who have not traveled in Europe, is that even though socialist and social welfare systems in Europe have been gutted too, it's still so much more robust, right? And so the stuff that we feel like we're fighting for is just taken for granted most of those places, including education. But like you said, that's an entirely other conversation altogether. I think because so much of what we've been talking about is about the way that things have been making their way through the courts and kind of a slightly, in a way that is concerning if you're concerned about these rights generally, especially because court decisions can be so long-lasting, can have these shadows into the future that are very, very broad. So is there cause for hope in terms of looking at the legislative branch instead? Is there pushback, you've mentioned some of the pushback in terms of like circuit and district courts.
Yes, I do think that there is hope in the legislative process, particularly here in Illinois, and I think that there are other states, probably on both coasts. I mean, we in many ways are anchoring the Midwest on that, and I think that's a really important thing to keep in mind. I also want to come back and talk about populism a little, because I do understand that's the theme of the class. And maybe, try to maybe redefine it just a little bit. I'm as a political science major, and I'm aware of the political science definitions of it. So maybe what I really want to talk about a little bit more is popular action. But there's been a recent discussion in some of the annals of political science, and it's begun to work its way into the everyday media. The New York Times and Vox have had a couple articles of late. And that's really the importance of popular action. And I'm going to tie it up to a question that Mr. Laudy asked me at the beginning of this, which was really sort of the limits on the rule of law. And what this discussion really is focused on is what should we do when maybe the rule of law isn't working so well? Not that we're violating it, not that we're not trying to enforce it, but when you have actions like the Trump administration, and some of the examples that we gave, that Mr. Lottie and I were talking about before the session started, were, the federal courts ordered the Trump administration to reunite migrant children with their families. And a combination of resistance by the Trump administration and ineptness really, prevented for a long while and then substantially delayed the reuniting of those families and the reuniting of those families. And what should we do as people, and what impact do our actions have on our government? And so, starting local and going broad. So locally, this is my plea to everybody to actually be engaged and stay engaged, and to not get complacent. So, if you haven't written a letter to your member of the Illinois General Assembly thanking him or her for voting for the Reproductive Health Act, it's not too late. And certainly the show of popular support for that, which we as advocates engineered by doing some polling, which we as advocates helped engineer by activating, our action alerts and calling our supporters and asking them to call or write their legislators, is part of it. But I think that the responsibility of every person in this country is to be engaged and to communicate with your elected officials and representatives your views on how they ought to use the power with which we've imbued them by virtue of electing them to office to do the people's business. And I know that makes me sound like I am probably, some idealist that was around, in 1787 or 1776, but it does work. And I think that one of the pernicious things that forces on the right have really tried to do is demoralize everybody and make people think that it doesn't matter what you do and it doesn't matter who's in power because you're going to get screwed anyway.
Right.
And that does not have to be the case. And it really matters. It really matters that people be engaged at a granular, individual level. And just again, to use the Reproductive Health Act as my case study, we would not have passed the Reproductive Health Act but for a couple of really important phenomenons. One legal, one sort of political action. The legal part of it is that I and my colleagues at the ACLU, even before I got there, spent 50 years using litigation as a tool to go to court and get the courts to enjoin or prevent the enforcement of state laws that restricted access to contraception, abortion, assisted reproductive technologies. Our colleagues in the sort of direct action and political action worlds embarked on what was really a 30-year effort to change the Illinois General Assembly. When I first started at the ACLU, the Illinois General Assembly was passing at least one restrictive abortion and contraceptive law every year.
Wow.
That situation persisted, actually even before I got to the ACLU, basically from 1973, which is the year that Roe was decided, until 1995, so 20 some years. That was the state of the world here.
Wow.
Starting in the early 1990s, a number of activists, some in the Democratic Party, some in the Republican Party, some in sort of political action groups, began a concerted effort to identify legislators who were anti-abortion, anti-contraception, anti-women, to recruit candidates to run against them, and to do the hard organizing work of talking to constituents about why these issues are important, and the fact that, really quite frankly, we the people have the power to actually change things. And so we have gone from an anti-choice legislative state to a pro-choice legislative state. We've seen similar developments and are seeing similar developments in other human rights areas, whether it's surveillance, whether it's criminal justice reform, economic justice, and the intersectionality among all these. But it's really sort of what I will call an integrated advocacy strategy. Mm-hmm. And I really want to be very clear, not just the ACLU. I mean, there's legal work, there's legislative work, and there's a lot of organizing and direct action work. Now, taking what we've done here to sort of how we operate as a citizenry in a world in which the rule of law is going called into question at all points in time. This is again where some of the political science research has really, I think, struck a nerve in me, or a responsive mm-hmm. nerve in me, because it sort of reinforces what we've seen at the ACLU from a legislative, from a legal perspective. The direct action of millions of Americans pouring into the streets, whether it was the women's marches, on the 21st of January, or taking the Muslim ban. Literally, thousands of people across the country came to airports, really literally across the country. That show of public opposition, coupled with the legal action that the ACLU took and that the Attorney General of several states took, really changed, not as much as I'd like, but really changed the course of affairs. Even though the Supreme Court upheld the third Muslim ban, and I think that's going to go down as one of John Roberts' Dred Scott decision in some ways. Depending on what the court does on DACA. The third Muslim ban, pernicious as it was a whole lot better than the first Muslim ban or the second Muslim ban. And in the course of the months between the first Muslim ban and the Supreme Court decision, literally thousands of families were reunited because the worst impact of that Muslim ban was really not on visitors from those countries. It was people like our clients at the ACLU of Illinois. A grandmother and grandfather from Iran who were lawful permanent residents of this country, whose children were citizens of this country, and who were trapped at O'Hare by Customs and Border Protection enforcing that first Muslim ban because they had been abroad for a family wedding.
Wow.
And that's just the example that elucidates what really was at stake. And but for the public outcry, but for the legal action, we would not have moderated that policy. The same thing is also true about the family separation situation. The ACLU went to court in March of 2018 on that. And that policy was not really stopped, until well into the summer of 2018. Footnote, I'm skeptical it's really been stopped.
Right.
But they withdrew the policy and the executive order because of the public outrage about it. And it really makes a difference when people, come out and say,
Yeah.
We are better than this.
Yeah.
We are better than this. You are not going to do this in our name. And so, really, I think that, we are reaching that time again where I think that, people have to think about whether, we need to, go back in the streets and express public outrage about some of the actions that are being taken. I think had the Supreme Court not finally, but by a very slim margin, prevented the Census Bureau from actually putting a question about immigration status on the census form, that would have been another, sort of another situation. And there's, the docket this year is really, of the Supreme Court this year, has a number of really groundbreaking cases that I think that, we need to think about, again, saying, if we lose those, we're better than this. And three of the cases that are up there this term involve the question of whether people who are members of the LGBT community are protected by Title VII of the Civil Rights Act against employment discrimination. One of those all of those cases were ACLU cases, but one of the cases that came out of Michigan was litigated by lawyers in our office. And in the confines of this room, we could win that case or we could lose that case. And just going back to the theme here of, I guess all politics are local, or let's use the tools we have. The case involving the rights of people who are transgender came out of Michigan. Had that case come out of Illinois, we wouldn't be in front of the Supreme Court, because Illinois has a state human rights act in which, and this is where I'll pat myself, but not me personally, but sort of pat the ACLU on the back. The ACLU, and I'm going to get my math wrong, it was probably 15 or 16 years ago, was part of and drafted the provision that specifically protected gender identity, as well as sexual orientation for people who are LGBT in the Illinois Human Rights Act. And so that's what we wrote into the law, and we have a number of cases, including several that are still ongoing, in which we have used the State Human Rights Act to protect the rights of LGBTQ students. I'm talking about students, to use bathrooms and locker rooms consistent with their gender identity, and have really challenged employment discrimination and public accommodation discrimination against people who are LGBTQ. And so we have likely, I hope not, because the federal courts have interpreted Title VII pretty consistently, not entirely, but pretty consistently, to protect against discrimination for people who are LGBTQ. If the Supreme Court upends that, thank God we're in Illinois. But again, all is not lost, and this is where the argument got complicated. Congress, unfortunately, for years has had introduced but has not passed basically a number of bills. The acronym that is most commonly used is the Employment Non-Discrimination Act, ENDA for short. That would protect, that would amend Title VII to protect against discrimination for people who are LGBTQ. Those bills have stalled, usually in the Senate. Thank you, Mitch McConnell. But even if the Supreme Court comes out the wrong way here, that'll be a statutory decision, not a constitutional one. And it's incumbent upon us and our friends and family and colleagues across the country to make it known to the members of the U.S. Senate, because the House has passed it a couple times, that they really need to pass the Employment Non-Discrimination Act to amend Title VII.
So I feel like we have just covered so much terrain, and there's still so much more that we could cover. I want to just make sure that we have at least a little bit of time for questions, because I know that there's just so much that, again, there's just so much here. So areas that you guys anybody here would like to ask more about, given that Colleen really knows kind of everything that's going on with ACLU of Illinois. She's a great person. Well, on some at a bird's eye overseeing kind of perspective. So any questions from folks in the audience, other than the ones we've had already?
Yeah.
What is the ACLU doing to combat fake news?
What is the ACLU doing to combat fake news? That is a question that I don't have a good answer for. The best answer I can give you is that the ACLU has been very vigilant throughout our history, even before the term fake news was part of the vernacular, in our defense of freedom of the press. And what we have done historically is we have either challenged restrictions by the government on the press, or we have partnered with the press in challenging restrictions. So for example, recent things here in the city of Chicago, the ACLU has often partnered with or filed what we call friend of the court brief when various, the Tribune, Sun-Times has actually filed Freedom of Information Act requests for police records involving, the Laquan McDonald case was really, quite frankly, in some ways, I guess that's one thing. It was a good example of certainly not police behavior or anything else, but the media, including independent media like Jamie Calvin, really forced the city's hand in terms of disclosure of the records, the videotape, and then sort of the discussions by police and city brass on that. So that's the best answer. In some ways, that's the easiest answer. I think that the real challenges we face as a society, and this is where I'm keeping my ACLU hat on, but maybe tilting it a little, are whether the ACLUs and other free speech advocates First Amendment doctrines have to be adjusted in light of the threats to our society posed by the internet and the ability to proliferate threatening, violent, fake news stories. So before I go down that route in any more detail, I'm just going to say is a really hard question, I think, not just for the ACLU, but for society writ large, because embedded in all of the claims of fake news and it's not just Trump, it's anybody in public office who doesn't like the press coverage, is the notion that government should be able to restrict, government should be able to decide what's fake and what's real. And that is what's so anathema to the ACLU, because we have no confidence that the government can be trusted to be a fair arbiter of that. That being said, and I really firmly believe that, and when you look back, to the founding, past the founding days, but I mean the Jefferson-Adams political dispute and that presidential election was really, really nasty. I mean, horrible things were said. I mean, horrible, scurrilous, false things were said by each of those candidates and campaigns against each other. Horrible things. And it really embodies why, again, the First Amendment exists, because it was sort of the voters are going to have to sort this out. But we are now in a very different time, and I think that where I'm ultimately coming down is that we certainly don't want to empower the government with the ability to say what's true and what's false. But I think that we need to re-examine, and we may come out in the same place, the ACLU, whether we think that two doctrines which have really allowed a lot of speech that is dangerous to people's safety, potentially, needs to be re-examined. And so now I'm going to go real into the weeds, if I can, for just a minute. So there are, contrary to sort of the myth that the First Amendment means that there can be no restrictions on speech. That's just not true. It's not true legally. It's never been true legally. Certain categories of speech are unprotected by the First Amendment. The easiest thing, or the easiest category that probably everybody, except people who are truly sick, agree about. Child pornography is not protected speech. And it's not protected speech, for the very obvious reason, probably many more, not just that it offends, our values as moral, ethical people, but because it really hurts the victims. And so along that same line of being concerned, and probably is for impact on other people, speech that hurts other people may not be protected, sometimes is not protected. So for example, speech that is a true threat is not protected. And speech that is truly inciting other people to immediate lawless action is not protected. But the courts, historically, being urged by the ACLU, have really said that that threat has to be real and immediate, and that incitement has to be real and immediate before before it can be restricted by the government. And so, the classic case came out, one of the classic cases came out of California, Cohen versus California. And it came out of the 1960s or early 70s in the anti-war demonstration. And there was an old chant, hey, hey, LBJ, how many kids have you killed today? And one of the speakers at a rally got up, in Berkeley and said, if I had I've got my draft card here. If I show up, they're going to train me. They're going to give me a rifle. And the first thing I do, if I got that rifle, I'm going to if I've got LBJ in my sights, I'm going to pull the trigger. So he was arrested. I don't know if he was arrested at the rally or not, but there's a federal law, no surprise, that makes it a crime to threaten to kill the president or threaten violence against the president. And so he was prosecuted. Basically the question is, can he be prosecuted under this law? And the Supreme Court ultimately said, get a grip. He's 3,000 miles away. This is classic political speech. He's, maybe it's not a wise thing to say, maybe not, it's not a couth thing to say, but really it's a political rally, it's political speech. He's expressing his opposition to the Vietnam War. This is protected. He's not really threatening LBJ. Right. So what is the relevance, and I'm going to throw this back to you, of that precedent, Cohen versus California, to the case of that horrible shootings in San Antonio, Texas, at the Walmart, where the gunman had posted some of President Trump's anti-immigrant rhetoric. We're not going to prosecute the president for it. He's protected. He's immune from that. But do we want? Should we actually think about government-imposed restrictions on the internet, keeping such posts up, or perhaps even worse, the kind of inciting posts where people urge other people to violence? I mean, 4chan, 8chan, some of those sites are very inciting of violence. And when you look again at the profiles and what some of the mass shooters have posted, they basically say point blank, I'm following the direction of, fill in the blank, the horrible killing in New Zealand, the horrible killings at the church in Charleston, South Carolina. And it's a really uncomfortable place, I am going to say, as a free speech advocate to be in, because, Cohen versus California looks really easy now. But, for the same, reasons that, the U.S. government used the Patriot Act to shut down the extreme Islamic sites that were encouraging people to violence. Should we think about that with respect to some of these hard right groups? And footnote, just in terms of the factual validity of it, the number of people in the United States who have been killed by right-wing violence far, far, far exceeds the number of people, who have been knock on wood, I mean, there's not been I think the incident out in San Bernardino, California in 2015 was 2014, I think it was December of 2014, was the last sort of attack and loss of human life in the United States linked to Islam, ostensibly linked to Islamic violence, as opposed to, I mean, just this year alone, you've lost track of the vision. So I'm going to ask the questioner, what do you think?
Well, this is what I'm writing my essay on, so I should have some idea.
Call Rebecca.
I'll tell her you said that.
It's really hard thing to think about because you have free speech on the one hand,
Right.
you have dangerous people on the other hand, and also just like things that damage how we think about certain things like anti-vax, like we restrict anti-vax posts, like they pose a threat to more than just those people. I think that like the laws in Singapore on fake news, like I don't think those are actionable at all. I don't think that should ever happen in the US. Right. I think that more responsibility needs to be put on to these platforms. I think like Facebook needs to have a better monitoring system, and they need to forward those threats onto the government.
Yeah, I mean, interest. I mean, I think that putting those restrictions on the platforms is inevitable if the platforms themselves don't adopt them, and some of them have, but they're probably not robust enough. Right. I would say that the reporting to the government requirement probably already, in some ways, exists, but it's not legally. It's not written. People aren't penalized for doing it, and I'm, except in the context, again, going in the child abuse context, and child, we are all, doctors, nurses, teachers are all mandatory reporters under the child abuse laws, right. To report to the government, suspected incidents or evidence of child abuse. There's no comparable obligation of which I'm aware that extends more broadly to the populace. There are laws or regulations that impose those kind of reporting requirements on some of the on banks and on insider trading in the private context, and on certain governmental actors or certain military actors. You've got a requirement under the the Uniform Military Code to report war crimes or crimes against humanity. I'm a lot uncomfortable probably with extending a mandatory reporting requirement to society at large. But I would say, this might be the time for really, again, assessing our own civic responsibilities, and if we stumble across something and it does really appear to be threatening, like many people do. I mean, if you think that a crime is being committed, you call law enforcement.
This is such an interesting road to be going down. I wish that we weren't going down it right sort of as we were ending, but unfortunately we do need to wrap up. It's about 4:35. So hopefully you'll all join me in thanking Colleen for her time, and thanks to you guys for all coming.
Yes, thank you very much.